If a dying person transfers a deed to real property to person A, but had a will that states that when person A sells the property, they are to split it with A, B, and C, does the deed trump the will? I really like this this question a lot, because this happens all the time where people come into my office and they want something to be legally enforceable in a will that there is no way to make legally enforceable. And this is a perfect example in this comment here. So essentially, it's sort of the scenario of trying to, have your cake and eat it too. Basically, a lot of people will want to deed property before they die, typically so that that property doesn't have to go through probate. Maybe that's not always the reason, but a lot of times I do see people, on their deathbed, for lack of a better way to put it, wanting to give property away so that it doesn't go through probate. Now, we all know from my countless other videos in Florida, there is no need to do anything like this. It's much better to get a ladybird deed in place. It's going to achieve the goal in a much better fashion for everyone, and it can be done whenever, and you don't have to give up your property rights. But again, that's for other videos. So if someone is, say, essentially just trying to get rid of the property because they don't want it in their estate when they pass away, they don't want it to have to go through probate. And they know if it's in their will, because remember, a last will and testament does not prevent probate. Just the opposite. It's used for direction in probate. It lets the court know who you want to get your assets or what's supposed to happen to your assets at the end of the probate process, which again is collecting all your asset information, collecting all the creditor information, seeing who needs to get paid, seeing if anything else needs to be handled before assets can be transferred to other people. So the will sort of lets the court know what your wishes are. It's the probate guideline, does not avoid probate. So if we just had this house in a will, the will can say who the house goes to. You can do that. You can give that for direction. It would have to go through probate first. Now, the will can't get fancy as far as I want to give it to this person and then I want this person to eventually sell the property, and when they sell the property, I want it to be split between these people. No, if you want it split between several people, you just have to split it between those people in your will so they all have equal ownership. You can't do fancy things like this in a will. This is more for a trust. In the specific scenario, though, the question is, we have this will, right, that states this property is going to A, but when A sells the property, whenever that is, A has to split the proceeds from this sale between A, B, and C. But there's a hook on this one because the property was actually transferred to A before the person passed away. Now, assuming it's a valid transfer, meaning the person was competent to make the transfer. No one's going to challenge it, right? They had competence to do it. They weren't completely drugged up. They understood what they were doing. All the boxes can be checked that it was a valid transfer, right? If it was a valid transfer, then A owns the property. A can do whatever A wants, regardless of what is in the will. The will cannot, the last will and testament, cannot enforce something upon A when A is the owner. This goes the same for bank accounts that people put in their will. They want the bank account distributed between all my children, but they only include one child as a beneficiary or POD on that account, or they name that one child as a joint account holder. Well, guess what? All the money in that account goes to one child. If that child wants to honor mom and dad's wishes, mom's wishes, dad's wishes, and split up the money how it was said in the will, they totally can do that if they want to do that. They're under no legal obligation to do that, right? They don't have to do that. Also, what makes it even more complicated, and people don't think about this when they're trying to save money with just a will or beneficiary designations, is what happens when one person inherits assets, whether it's a financial account or a home, and then they're left with this dilemma of, do I now gift it to my siblings or give it to these other people? That can set up weird tax situations for everyone involved. So not only, is it not worth the money that you may save by not setting up a trust, it can be disastrous and cause lots of headache and lots of extra money for your beneficiaries. So these are things to think about of why you may want to consider slightly more advanced planning, or at least speaking to an attorney and hearing them out, because saving $2 today, isn't worth wasting $100,000, in a few years or whatever it is, right? It's a classic example of no one's rich enough to buy poor, because you buy things that aren't of good quality, they break. It's the same with estate planning. You set up a plan not of good quality, or you try to take it into your own hands, never ends well, right? So in this scenario, to recap, yes, if A owns the property, the deed does trump the will. Assuming it's a valid deed, trumps the will. A, you're the owner. If you want to sell the property and keep all the money yourself, you can. If you want to honor the wishes and split it between A, B, and C, you can. If you just want to live in the property for the rest of your life and pass it down to someone else entirely, you can. Legally, you can do whatever you want because you are the valid owner. And that's going to be a decision, more of a moral decision at this point, or ethical decision, than it is a legal one. But it's a good reminder for everyone out there who thinks, they can list a beneficiary on something or give something to someone in advance as a joint owner or as the sole owner, and then later say in a will what they want that person to do with it. You can't do it. Once they're the owner, they're the owner. All right, I hope this answers the question. Any other questions about wills or deeds or trusts or how these things work and you're in Florida, don't hesitate to contact us. We're the non-stuffy attorneys at Cause Law Office, and the link is in my bio.